To inform you of the charge or charges pending against you.
La primera comparecencia la voy a informar del cargo o cargos que pesan en su contra.
I will then determine whether or not there's probable cause for those charges.
Y entonces voy a determinar si existe o no causa probable por esos cargos.
If I do find probable cause, we'll discuss what conditions, if any, are appropriate for your release.
Si yo determino que existe causa probable, entonces hablaremos de qué condición o condiciones serían apropiadas para su libertad.
If I do not find probable cause, you'll be released on your own recognizance.
Si yo determino que no existe causa probable, usted saldría en libertad bajo palabra.
Because these are criminal charges, you do have certain rights.
Debido a que estos son cargos penales, usted tiene ciertos derechos.
You have the right to remain silent.
Usted tiene el derecho de mantenerse en silencio.
Everything you say is being recorded and may be used against you.
Todo lo que usted dice está siendo grabado y podría ser utilizado en su contra.
You have the right to have a lawyer help you with your case.
Usted tiene el derecho de que un abogado le ayude en su caso.
Everything you say is being recorded and may be used. Even if you cannot afford an attorney, one will be appointed if you ask.
Aún si usted no puede pagar por un abogado privado, se le asignaría uno de oficio.
I sometimes switch up the order when I say those. Okay. All right, the first one I've got is Wesley Shaw, 21 CF 813 and 21 CT 1174. And was everyone in this room sworn?
Yes, sir.
And I do have a state attorney and a public defender present, starting with the state. Please announce your presence.
James Stewart for the state.
All
right. Good afternoon, Mr. Shaw. So you're here for the following charges. One count of escape, one charge possession of marijuana less than 20 grams, one count of giving false ID to law enforcement, and there's a fourth count on here that doesn't make a lot of sense to me. I don't know what this is. It's not really a charge. 901.15 sub 4 is not a charge. I don't know what to do with that. Would you like to have a public defender appointed to assist you, sir?
Yes, sir, right now.
Very well, sir. I'm going to go ahead and appoint the public defender at this time. I've reviewed the probable cause affidavit. I do find probable cause on counts 1 and 2, but not count 3. There appears to be recantation prior to any formal arrest or anything like that. And then, like I said, Mr. Stewart, I don't know if you see what I'm looking at, this 901.15, that just authorizes a warrantless arrest under certain circumstances.
Yes, I don't know if that's something that DOC put out when they realized he was missing, but I agree. If the court's going to take no action, that's fine.
There's not even a finding I can make on that. I'm just going to take no action on it. It's not really a charge. All right. Bonds will be set as follows. On count 1, 20,000. On count 2, 2,000. And then ROR count 3. All right. Good luck to you, Mr. Shaw. Take care. All right. Was there anybody else in this room that needed to be taken out of order? All right. Starlin Abada Zuna, 21 CF 809, 21 CT 1170. Good afternoon, sir. So you're here for a charge of operating a motor vehicle without a license, giving false information to law enforcement, and possession of marijuana over 20 grams. Would you like to have the public defender appointed to assist you, sir? All right, I'm going to appoint the public defender at this time. I've reviewed the probable cause affidavit. I do find probable cause on all 3 counts. Bonds will be set as follows. Count 1, 1,000. Count 2, 2,000. Count 3, 5,000. Good luck to you, sir. Domingo Francisco, 21 MM 802. Good afternoon, sir. So you're here for a charge, sorry, 2 counts of resisting an officer without violence. Would you like to have the public defender appointed to help you, sir?
Is there a way I can get an ROR?
Well, my first question is, do you want a lawyer to help you out?
Yeah.
All right, I'm going to appoint public defender at this time. All right, I do find probable cause on both counts. I'll be honest with you, Mr. Francisco. Your request for an ROR is denied. Given your prior criminal history, given the fact that not once but twice it's alleged that you fled from the police, bonds will be set as follows. In 21 MM 802 and 21 MM 803, $5,000 on each count. Good luck to you, sir. Really? Mr. Stewart?
Judge, if that includes a GPS, I don't object.
Didn't.
Well, if he goes on pretrial, that would be my request.
The prior felony conviction for possession of controlled substance is recently, at least the VOP was as recent as 2019. And given the two times they said that he fled from police, I'm disinclined to put him on pretrial supervision. So I'll be honest with you, sometimes that risk assessment score sheet baffles me. All right. I mean, I understand you guys just follow the rules, but sometimes it has results that don't make sense to me. All right, Benji Garza, 21 CF 808. I'm sorry? Okay. That echo messes me up. The echo. You're better at understanding what than I am. Good afternoon, sir. All right, sir. How are you? Okay. So you're here for a charge of driving on a suspended license as a habitual traffic offender. Would you like to have the public defender appointed to help you, sir? I'm going to appoint public. I'm sorry, I cut you off. What were you saying? Okay, you did. All right, very good. All right, I'm going to appoint public defender at this time. I reviewed the probable cause affidavit. I do find probable cause. Bond is set at $5,000. And State, do you have a request?
Yes, Judge. He is on probation right now in 20284 CF, so asking the court to sign a Widman Act warrant in that case.
All right. So, Mr. Garza, what's going on is this. You're currently on probation in 20 CF 284 for the same offense. The state has asked me to start a violation of probation proceeding against you, so I'm going to do that by signing this warrant, okay? This is going to be served on you today, and I'll see you tomorrow so we can talk about the VOP, all right? All right, I'll see you tomorrow, sir. Edwin Lopez Garcia. And I'm sorry, real quick. Abel Garcia Pacheco. Is that person present? Do we have a case like that? Because it's on my list, but I don't have a file.
Your Honor, it was ordered to be in custody and it will go on. So the defendant wasn't supposed to be on the court docket. So it's not going to be heard.
Very good, thank you. All right, so is this Mr. Lopez Garcia?
¿Está el señor López García?
Lopez Garcia? Yes.
All right, very good. Good afternoon, sir.
Buenas tardes, señor.
This is 21 CT 1171.
Este es 21 CT 1171.
So you're here for the following charges.
Señor, usted está aquí por los siguientes cargos.
4 counts of DUI with damage to property.
4 cargos de DUI con daños a la propiedad.
1 count of leaving the scene of a crash.
Un cargo de abandonar la escena de un accidente.
1 count of driving without a valid license.
Un cargo de manejar sin licencia de conducir válida.
And 1 count of DUI with a breath or blood alcohol level above a 0.15.
y un cargo del DUI con un resultado de sangre o del aliento de más de 0.15.
Would you like to have the public defender help you with your case?
¿Usted le gustaría que el abogado de oficio le ayude con su caso? Yes.
All right, we're going to appoint public defender at this time.
Muy bien, voy a asignar al abogado de oficio en este momento.
I have reviewed the probable cause affidavit.
Yo he analizado la declaración jurada de causa probable
Do you find probable cause on all counts?
y voy a determinar que existe causa probable para todos los cargos.
Bonds will be set as follows.
Las fianzas van a ser las siguientes.
On counts 1 through 6,
Por el cargo del 1 al 6,
bond will be set at $1,500 per count.
la fianza va a ser 1.500 por cargo.
On count 7, which is the DUI with the enhancement,
Por el cargo 7, el que es el DUI con agravante,
bond is set at $2,000.
la fianza la voy a fijar en $2,000.
As a condition of release, should you post bond,
Como una de las condiciones de su libertad, si usted paga la fianza,
you may not possess or consume any alcohol,
usted no puede poseer ni consumir alcohol,
and a SoberLink device must be installed prior to your release.
y un dispositivo llamado SoberLink tiene que ser colocado en el carro antes de salir de la cárcel.
And state, do you have a motion at this time?
Y Fiscalía, ¿usted tiene una petición en este momento?
Your Honor, the defendant's out on bond in 21261 MM, 21373 CT. We're asking the court to revoke his bond in those cases.
Señoría, en el cargo 21-261 TF y 21-373 CT, vamos a pedir que cancele esa fianza.
That motion is granted.
Esa petición es concedida.
Good luck to you, sir.
Buena suerte a usted, señor.
Stephen Morris. Okay. This is 21 CT 1173. Good afternoon, sir. So you're here for a charge of driving on a suspended license. Would you like to have the public defender help you with your case today? All right. John was asking for a plea offer, Mr. Stewart.
Judge, we would need to recall that so I can take a closer look at that.
All right. You're asking for a plea offer, is that right? So you're asking for a plea offer to try to resolve your case today, is that right? Would you like to have a public defender help you out with that?
No, sir. I mean, I just want, I don't do my job. Your job is, maybe it's one thing,
Okay. All right. Let me give the state attorney a moment to consider what they want to do, and I'll be right back with you. Okay, sir? All right. All right. Charlie Irvin Prey, 21 CF 811. Good afternoon, sir. Sorry. Also here for 21 CF 812. So you're here for the following charges: 1 count of possession or use of the identification of another, 1 count of possession of stolen credit or debit card, 1 count of fraudulent use of credit card, 1 count of grand theft auto. Would you like to have the public defender help you with your case today? And appoint public defender at this time. I've reviewed the probable cause affidavit. I do find probable cause on all counts. Bonds will be set as follows. In 21 CF 811, bond will be set at $10,000 per count. You may not have any contact with the alleged victim, nor may you return to the location where this is alleged to have occurred. And then in 21 CF 812 for the charge of grand theft auto, bond is set at $10,000. You may not have any contact with the alleged victim or return to the location where this is alleged to have occurred. Good luck to you, sir.
Judge, I have a motion in one of his pending cases as well.
Yes, sir.
He's out on bond in 21605 CT, and I'm asking the court to revoke his bond in that case.
The motion is granted. All right, Mr. Prey, I'm sorry, you had a question, sir.
How many
Total bond is $40,000, but I just revoked your bond in 21 CT 605. All right, good luck to you, sir. Ronaldo Rodriguez, 21 MM 801. Good afternoon, sir. So you're here for a charge of criminal mischief, less than $200. Would you like to have the public defender help you with your case? I'm going to appoint the public defender at this time. The showman does not qualify for pretrial release? Okay. Oh, I see. I missed that. Okay. All right. I'm going to appoint public defender at this time. I have reviewed the probable cause affidavit. I do find probable cause. Bond is set at $1,000. You may not have any contact with the alleged victim or the witness who's indicated in the probable cause affidavit. That's it. Good luck to you, sir. Joseph Owen Stevens, 20 CT 2585. Good afternoon, sir. Sir, you're here for a warrant for failing to appear. Find it here. Just a moment. Can I find it? Here it is. For failure to appear for your non-jury trial, looks like Monday in front of Judge Adams. Did you have a lawyer on that case already? You did not? Would you like to have the public defender appointed to help you with your case today?
Today, I did ask someone when that came prior, I don't have contact with me.
Okay. All right. Were you supposed to appear on Zoom, or was it supposed to be in person? Okay. All right. Well, I reviewed the warrant. I do find probable cause. Judge Adams set a bond of $4,000, so you can still bond out, and you'd have to come back to court on June 3rd. Okay. All right. Good luck to you, sir. All right. Yoslandi Valdez. Is it okay?
Yoslandi Valdez,
20 CF 430, 21 CF 814.
20 CF 430, 21 CF 814.
All right. Good afternoon, sir.
Buenas tardes, señor. Good afternoon.
Sir, you're here for a charge of driving while license suspended
Señor, usted está aquí por un cargo de manejar con la licencia suspendida
and a violation of state probation.
y violar la libertad probatoria estatal.
Would you like to have a public defender help you with your case, sir?
¿Usted le gustaría que un abogado de oficio le ayude con su caso, señor? No.
Okay. Does that mean you want to represent yourself?
Ok, ¿eso quiere decir que usted se va a representar usted mismo? Yes.
Okay. All right. I reviewed the probable cause affidavit.
Ok, yo leí la declaración jurada de causa probable.
I find probable cause on both counts.
Voy a determinar que existe causa probable para ambos cargos.
Bond on count 1 is 5,000.
La fianza por el cargo 1 es 1,000
And on the violation of probation, no bond.
y para la violación de la libertad probatoria no hay fianza.
Good luck to you, sir.
Buena suerte a usted, señor.
All right. Thank you. Was there anybody else in that room, or do we need to switch?
Judge, we can address Mr. Morris if you'd like.
Okay. Hold on. Let's go ahead and recall Mr. Morris, Stephen Morris. Once again, this is 21 CT 1173. Mr. Stewart, what is the offer?
So, Judge, he has two cases pending now. There's another one, 20 CT 191. So
Hold on.
the
Wait,
offer,
you faded out for just a moment there. What's the other one?
I'm sorry, 20 1891 CT, same charge. So my offer in that case would be to amend the charge to a no valid driver's license, adjudication, court costs, cost of prosecution. And in this case that he's here for today would be to plea as charged, adjudication, 5 days jail, credit time served, court costs, cost of prosecution.
All right. Mr. Morris, did you hear all that?
Yes, sir, I heard it, but I didn't know if you can put out.
All right. All right. I'm gonna repeat what he said, and if you don't hear me or if you have any questions, please ask, okay? All right. So you have another pending case right now. The state attorney is willing to amend that charge to just driving without a valid license, conviction, time served, and cost. Correct, Mr. Stewart?
Yes.
All right. On this one, this new charge, it'd be a conviction, 5 days in jail plus cost. I'm sorry? You'll take that deal? Nope, the other one is time served. Yes, sir. He says he wants to take the deal. Now, NJC, do you guys have plea forms or anything like that available to you?
Your Honor, we do. I was just gonna ask you guys to echo factor in here, all the two case numbers, please.
Sure. It's 21 CT 1173
Okay,
and 20 CT 1891.
1891.
Yes, ma'am. Is that correct, Mr. Stewart?
Yes. Yes, Judge. Yes.
All right. So let's do this. Can we give Mr. Morris a plea form?
Yes, sir, I read one.
You read one. Do you have any questions about your rights that are contained in that form, sir?
No, sir.
All right. And you were sworn with everybody else? You already swore to tell the truth?
Yes, sir.
All right, very well. The state attorney is going to ask you some questions. I know there's an echo, so just do your best. And if you need us to repeat something, please let us know, okay? Mr. Stewart, go ahead.
All right, Mr. Morris, can you state your name and date of birth?
Stephen Ward, 1980.
You're entering a plea today to one count of no valid driver's license, which is an amended charge, and one count of driving while license suspended. Do you understand the plea offer in this case, which the judge and myself have put on the record?
Yes, sir.
And knowing that, how do you wish to plead to these two charges? Not guilty or no contest?
I think no contest, Your Honor.
Have you had the opportunity to read and sign a waiver of rights plea form?
I read it, but I haven't signed it, Your Honor.
Okay, do you understand all the rights on that form you're waiving when you enter your plea in this case?
Is he asking for him to sign it right now, Your Honor?
No, it'll just need to be signed at some point, obviously before he goes.
Yes.
All right, Mr. Morris, do you understand all the rights on that form you're waiving when you enter your pleas today?
Yes, sir.
You understand you're waiving your right to have a jury trial in this case?
Yes, sir.
You also understand you're giving up your right to file any motions on your behalf or to argue any defenses on your behalf at trial?
Yes, sir.
You're proceeding today without an attorney. Do you understand you have the right to an attorney in these cases? And if you can't afford one, the court would appoint one to represent you.
Yes, sir.
And it's your decision today to go forward and accept these convictions without the assistance of an attorney. Pardon me?
He said yes.
Yes, okay. Do you understand driving on a suspended license is an enhanceable offense, meaning if you commit it again in the future, you could be charged with a more serious crime?
Yes, sir, I do.
Do you understand that based on these pleas today, the Department of Highway Safety and Motor Vehicles could take additional sanctions or place additional sanctions against your privilege to drive? Do you understand that?
He said yes.
And knowing that, you still wish to go ahead with these pleas today?
Well, yes, sir. Yes, sir.
Okay. Do you suffer from any mental illnesses?
He said no.
Are you currently under the influence of any drugs or alcohol? Do you understand if you're not a citizen of the United States, these pleas could be used against you in a deportation proceeding?
Yes, sir.
Do you have any more questions for the court before you enter your pleas today?
No, sir.
Okay. We'll tender the pleas.
Well, go ahead, Mr. Morris. You have a question? Go ahead.
I just want to have both my charges will be taken care of, and then that should be over, right?
Correct. You're 5 days and you're done. Now, no, you have the financial penalties. You have to pay the money, right? And if you don't pay the court costs, there'll be additional suspensions on your driver's license if you don't pay everything. Okay.
Yes, sir. I'm glad you said that.
All right, but otherwise, no. Otherwise, you're done with your cases. Okay.
Thank you. That's all I need.
And is that what you want to do?
Yes, sir.
All right. Then in 21 CT 1173, I have reviewed the probable cause affidavit. I do find that there is a sufficient factual basis and venue. And in 20 CT 1891, I've reviewed the citation and find that there is a sufficient factual basis and venue. I've considered the colloquy for both cases and find that the plea has been freely, knowingly, and voluntarily entered. Therefore, I will accept the plea and impose sentence as follows. Which one do we have up first?
The 1173?
Yes, ma'am. All right. So in 21 CT 1173, for the charge of driving while license suspended, adjudication of guilt, 5 days in the county jail with credit for all time served, $220 in court costs, $50 cost of prosecution, 90 days to pay. All right. And while our clerk is doing that, sir, I just want to reiterate something to you. I'm looking at your driving record. I was just double checking. It looks like you have one prior conviction for driving on a suspended license in 2018. This is strike number 2. If you have a third conviction within 5 years, DHS&V will revoke your license for 5 years and you'll be deemed a habitual traffic offender. You understand?
Yes, sir. I do.
If you get caught driving on that 5-year revocation, if you get another conviction for this, you get caught on that, you can be charged with a felony and facing up to 5 years in prison, okay? So either get your license fixed or stop driving, okay?
Yes, sir.
All right. All right, so in 20 CT 1891, for the offense of, to the amended charge, drive without a valid license, adjudication of guilt, time served, $220 in court costs, $50 cost of prosecution, and 90 days to pay all financials in both cases. All right, good luck to you, sir. Take care, all right?
Thank you. Thank you.
All right, I believe that's everybody in this room. Is that right? Thank you.
Thank you.
And we did not need an interpreter in the other room?
Yes, sir.
All right then. All right.
They have been.
Can everyone there hear me?
Excuse me?
Oh, and JC, can you hear me?
Yes, Your Honor.
All right, good afternoon. All right, folks, you're here for first appearance. First appearance, I'm going to inform you of the charges pending against you. I will then determine whether or not there's probable cause for those charges. If I do find probable cause, we'll discuss what conditions, if any, are appropriate for your release. If I do not find probable cause, you'll be released on your own recognizance. Be okay? It's okay if you're cold. I just want to make sure you're physically all right. You okay, sir? All right. All All right. As I was saying, if I do not find probable cause, you'll be released into own recognizance. These are criminal charges, so you do have certain rights. You have the right to remain silent. Everything you say is being recorded and may be used against you. You have the right to have an attorney help you with your case, and even if you cannot afford one, one will be appointed by the court if you ask. And I do have a public defender present in the courtroom with me. All right. Do we have Mr. Singletary present? All right. This is 21 CF 807. Mr. Hollander, please announce your presence.
Lee Hollander on behalf of Charles Keith Singletary.
All right, Mr. Singletary, your lawyer is present in the court with me, okay? So you're here on a charge, well, the charge on the booking sheet is aggravated assault. I reviewed the probable cause affidavit. I do find probable cause.
Judge,
Yes, sir.
I'm not debating probable cause from the booking sheet.
Okay.
What I am asking for is a $5,000 bond. Mr. Singletary has been here living here in this area most, if not all, of his life. He has brothers, sons, daughters. They have daughters here. He's not a flight risk. He is on federal parole, and not going anywhere, Judge. They may or may not do anything pending this case. He has no failure to appears that I'm aware of. Are you shaking your head? Yes, he does.
No,
Okay.
I'm agreeing with you. I'm not aware of any failures to appear.
Okay. He does not have a passport. If the court was to impose a no contact order, he does not reside at the same residence as the alleged victim here. So that's not a problem. And I just think a $5,000 bond is sufficient to ensure his appearance down the road.
Well, I like to hear the state's response, but my hesitation when I read the charge was, yes, there's probable cause for aggravated assault, but there's probable cause for other charges that I would have expected to have seen on here.
I understand, Judge. That's not
the allegation is that he cut this other man's head with a knife. Those are the facts that are being alleged. So my concern is not necessarily him being a flight risk. It's the safety of the alleged victim and the community as a whole. So I'd like to hear from the state.
Judge, my request was going to be $50,000 and no possession or consumption of alcohol as a condition of his bond. I think there was some testimony in the booking report about him being under the influence of alcohol. Obviously, this is potentially something that's more serious than a third-degree felony, and to whether he's a flight risk or not, I would say that he has a lot of exposure now, potentially between whatever charges filed in this case and then his pending federal issue. I did call and confirm that he is on federal probation right now, so I was also going to ask the court to issue a Whitman Act. They are going to be pursuing that based on what they told me.
that we're objecting to.
Well, I don't think I have the authority to initiate a federal VOP. I would if I had the authority, but I don't think I do. I don't think I have jurisdiction to do that.
I understand, Judge.
But I
Was that
I
50
assume,
or, I'm sorry.
yes, for 50, 50,
Oh.
000. I assume a federal magistrate will be addressing that soon enough.
If they even pick them up, it's a parole violation. It's not probation, as I understand.
Oh, did you represent him on the
No.
federal charge?
No.
Well, nonetheless, like I said, I mean,
Right now,
Yes, I understand. As of right
Okay.
now, it's a third-degree felony. The scheduled bond is $5,000, but they could very well have charged this as an aggravated battery. Potentially even worse. We'll see what the facts bear out. I'm inclined to agree with the state for that reason. Bond will be set at $50,000. So you may not have any contact with the alleged victim or the witness who's listed in the probable cause affidavit. You may not return to the address where this is alleged to have occurred.
wait, Judge, that's his address. That's
This is not the victim's address. This is the,
no, the 2690 is Mr. Singletary's house.
state, do you have a Vine form, something like that? You can confirm the address of the victim being different than the address where the incident occurred?
That's what I'm looking for, Judge. Judge, it doesn't appear I was given a Vine form for this case, so I do not have that information for the court at this time. Can,
What shall we do about that? I mean, Mr. Hollander is representing that this is not the victim's address, that this is the defendant's address. The victim does not live there. And I am missing a no contact order.
well, Judge, obviously I don't dispute the intentions of Mr. Hollander.
I know.
I don't know if he's getting that information from the defendant, then
Nope, I'm getting it from the defendant's granddaughter. Brooke is your granddaughter?
I guess, Judge, if you enter a no contact order and he goes there and the victim is there for whatever reason, then he would have to leave. I suppose that's another way to look at it.
I would agree.
Okay, but I want to be able to go there. That's his house. The victim is not going to show up there.
I certainly hope not, for his own safety and sake. But sir, if the victim happens to be there when you go home, you're gonna have to find somewhere else to go. You understand?
My house. My daughter, my granddaughter, my wife, and me stay in my house. Just remember, come by.
I understand. But what I'm saying is, if he happens to be at this address at your home, and, if you're out somewhere, you come home and he's there, you don't get to go in. You're gonna have to find someplace else to go until he leaves. You understand?
Okay?
The no contact order applies to you, not to him. You have to avoid contact with him. Do you understand that?
Yes.
All right.
I'll notify the family, Judge.
All right. As additional conditions of release, so you may not possess any firearms. And if you have any,
I just want to make sure that the no contact order does not bar him from that address.
no, I specifically removed
Thank
that.
you.
No, you're allowed to be at that address as long as the victim's not there.
Yes.
All right. So you may not possess any firearms, and if you have any, you must be turned over to the sheriff's office within 24 hours of your release. I am going to grant the state's request for a no alcohol provision. There was an allegation that this gentleman was severely impaired at the time. Whatever happened.
You understand, no alcohol, no possession or consumption. So
No problem.
tell everybody else in the house it's gotta go. Okay? All right,
All right. Good luck to you, sir. Thank you, Mr. Hollander.
thank you.
I saw that. All right.
Whenever you're ready, no rush. Sorry, Judge.
We're almost there, ma'am. I think I've got, there's a couple more. Yep.
Oh, okay.
Yep, we're almost there. I don't think we've ever done a 215 plea at 215.
No, we haven't done it.
We ought to just start making that
At
later.
3 o'clock.
Yeah. Okay, sorry, that's the rest of that file. All right, I've got Janice Jackson, 18 CF 1846. All right, good afternoon, ma'am.
Hello.
Ma'am, you're here for an amended violation of probation warrant. It's alleged you violated condition 7 of your probation in 3 different ways: by using intoxicants to excess, or possessing any drugs or narcotics unless prescribed by a physician. Allegedly being in possession of THC, as shown by an analysis of a urine sample. It's alleged that you violated condition 7 similarly for verbally admitting using Molly, and alleged violation of condition 17 by failing to attend support group meetings with a focus on drugs as directed by the court. This warrant was signed by Judge Martin. Did you have a public defender on your case already?
Yes.
All right.
I don't remember his name, but I was drunk or I
Okay, so this is signed by Judge Martin in drug court, okay? So the public defender shall be appointed again. I did review based on my review of the warrant, I do find probable cause. Bond is set at no bond. And you'll be seeing Judge Martin next week, okay?
Yes, sir.
All right, good luck. All right. Aya Osterk, 21 MM 800. Did I pronounce your name correctly?
Yes,
All right, good afternoon, ma'am. You're here for a charge of battery, domestic violence battery. Would you like to have a public defender appointed to assist you? All right, I'm going to appoint a public defender at this time. I have reviewed the probable cause affidavit. I do find probable cause. She does qualify for pretrial release. State, do you have any information to provide to the court at this time?
Judge, no prior criminal history that I can see.
All right. So, ma'am, your bond will be set at $2,000 or pretrial release. And what that means is that you don't have to put up any money in order to get out of jail today, okay? But whether you post the bond or you sign up for pretrial release, the following conditions will apply. You may not have any contact with the alleged victim. You may not return to the address where this incident is alleged to have occurred except for one time with the company of a law enforcement officer to obtain any personal items. You may not possess any firearms, and if you have any, they must be turned over to the sheriff's office within 24 hours of your release. If you sign up for pretrial release, you'll have the additional condition of a GPS monitor, okay? All right, good luck to you. Latasha Stillman. This is 21 CF 805. Good afternoon, ma'am.
Good afternoon.
Ma'am, you're here for a charge of harboring or concealing or aiding an escaped prisoner. Would you like to have the public defender appointed to help you?
Yes, please.
All right, I'm going to appoint the public defender at this time. I've reviewed the probable cause affidavit. This lady has no prior criminal history. Is that correct?
Yes, sir.
Ma'am, where do you live?
Lehigh, Florida.
How long have you lived there?
Lehigh, over 6 years.
All right,
And the current act is 3 years.
okay. Bond will be set at $2,000. Good luck to you, ma'am.
Thanks.
James Davis, 21 CF 810, 21 CT 1172. Good afternoon, sir. All right, so you're here for the following charges: possession of fentanyl, possession of drug paraphernalia, driving while license suspended, and possession of synthetic cannabinoids. Would you like to have the public defender appointed to assist you, sir?
Yes, sir.
I'll appoint public defender at this time. I review the probable cause affidavit. I do find probable cause on all counts. Bonds will be set as follows: count 1, 5,000, count 2, 2,000, count 3, 1,000, count 4, 5,000. And State, do you have a motion?
Yes, Judge, he's out on bond in 21678 CT, so we're asking the court to revoke on that case.
That motion is granted. Good luck to you, sir. All right. Is Barbaro Martinez still in the hospital? Yes, he is?
Yeah.
All right. We'll proceed in his absence. He's here for charge of DUI, possession of cocaine, smuggling contraband into county facility, and tampering with evidence. I reviewed the probable cause affidavit. I do find probable cause on all counts. Count 1 is 1,000. Count 2 is 5,000. Count 3 is 5,000. Count 4 is 5,000. That's it. Tarina Cypress, 20 CT 845. Good afternoon, ma'am. Ma'am, you're here for an alleged violation of county probation. And it's alleged you violated your probation in the following ways. That you violated condition 2 by not paying your monthly probation fees. You violated condition 5 by failing to live and remain at liberty without violating any law. Allegedly by possessing a controlled substance, specifically benzodiazepine. It's alleged that you violated condition 7 of your probation by failing to refrain from using intoxicants to excess or use or possession of a controlled substance, once again for testing positive for benzodiazepine. It's also alleged that you failed to attend and complete the 30 days on the weekend lockdown program. This warrant was signed by Judge Adams. Would you like to have a public defender appointed to assist you?
I have a private,
You have a private attorney? Who's your lawyer?
Jim Lewis.
All right. That attorney is not present today. Would you like me to have you brought back tomorrow so you can try to reach your lawyer? Or we can just go forward today. You're free to have the public defender help you today if you wish.
Yeah.
Very well. I'm going to appoint the public defender provisionally at this time. Having reviewed the warrant, I do find probable cause. Bond is set at no bond. Good luck to you, man. Emerson Garcia Rodas, 21 MM789. Good afternoon, sir. Sir, we had returned you to today because you wanted to reach out to your private attorney. Was that correct?
Yes.
There's nobody here. So what would you like to do? Very well. I'm going to appoint public defender at this time. You're here for a charge of affray. I reviewed the probable cause affidavit. I do find probable cause. Bond is set at $2,000. And this gentleman is already in custody in 20 CF 1437. State.
Judge, we're asking you to revoke his ability to post bond based on the new arrest.
Motion is granted. Good luck to you, sir. Last, I've got Ross Vincent Licari, 21 CF 806. Good afternoon, sir. Sir, you're here for a charge of petty theft, third or subsequent offense. Would you like to have the public defender appointed to help you?
Yes, sir.
All right. I'm going to appoint public defender at this time. I've reviewed the probable cause affidavit. I do find probable cause. Bond is set at $5,000. You may not return to the Walmart at 5420 Juliet Boulevard in Naples, Florida. Good luck to you, sir. Take care. I think that's it for first appearance, yes? Ms. Bryant, congratulations. You're up.
I don't know. Nice to see you both, actually. I have 2 cases for Timothy Brennan, and he is in custody.
Yes, I believe he is present. Give me just a moment. Yes, ma'am. Have a good day. Uh-oh, hold on. What's going on here? Who do I have in front of me? Is this Mr. Brennan? All right. Yep, he's here. All right.
Okay, Your Honor, there are two cases, 4 counts that we are playing to. It is case 20MM1658, which has a count for trespass and a count for petty theft.
Okay.
And then case 21CT622, which has a count for driving while license suspended, and we are pleading also to 1 count of DUI with property damage.
So that's count 1 and count 6.
Well, right now it's charged as DUI 3rd with damage. Is it, are you pleading to a regular DUI? Is it going to be amended, or is it going to be DUI 3rd with property damage?
I actually didn't talk about that with Mr. Rosinko, but I think it is, we're agreeing to plead to, it would be 3rd, I guess. 3rd with property damage, but 1 count. Everything else was going to be merged and dismissed, as well as 1 count for driving while license suspended.
Oh, hold on. Is it charged as 1st?
No, they're charged as DUI 3rd, all 5 counts.
Okay. So
Judge, it's a plea, from what I can gather from the notes, it's a plea to 1 count of DUI 3rd with damage and 1 count of driving while license suspended. The other DUI counts will be no prost.
Thank you. And I don't know if there's any citations we dashed, they be merged and dismissed. I think there was 1.
I don't see anything that was consolidated.
Okay. All right. So I believe Mr. Rosinko went over this with the clerk, but I can read it into the record if you want to make sure I'm correct.
I don't think he did.
He did.
Oh, he did?
I want her to do it.
Okay. All right. So go ahead. So start with the DUI case, yes? All right. So DUI case, what are the terms, please?
Okay. So there's a count for driving while license suspended, which will just be adjudication and cost. And correct me if I'm wrong, Mr. Strick. And then for the DUI with property damage, it's adjudication, $2,000 fine, 12 months probation, no early termination, 12-month suspension of driver's license, victim impact panel, 10-day vehicle impoundment, no alcohol provisions, substance abuse evaluation, follow recommendations, DUI school, 50 community service hours, ignition interlock. My client does not have a car, but that's still technically a term. And the agreement was 90 days jail, and he's been in for more than that, Your Honor. And I don't have the exact date, but I believe it's over 90, so we can put time served if you want to double check, or with credit for time served. He was picked up, arrested on the 17th of February.
You told me to do 90 days jail as a condition of probation, so.
Okay. That's fine. 9 days jail as a condition of probation.
Okay.
Credit for all time served. Does everyone agree that's how the judgment should read?
He should be getting out today, basically, and I just want to make sure that he does.
All right.
Because he was, with game time, he should have 100 and something days.
Well, I guess, Mr. Stewart, you can chime in here if you wish. You know, given that what we've been talking about before, the credit towards the total term of probation, I think it would be necessary to put that credit on the record instead of just doing time served.
Oh, this is maybe the easier thing to do. Based on the Google day counter, this would be 84 days. So my preference would be to just say 84 days jail as a special condition of probation and 84 days jail credit towards his probationary sentence.
Very good.
84 days jail. Do I put the credit time served?
Yes, credit for all
Okay,
time
and
served.
then I'm also gonna credit him 84 days towards probation.
Yes.
Right.
Okay.
And then also reserve on restitution. I'm sure that's on there. I don't know if it's in that.
And Mr. Stewart, you have a notation to file that the victim's been contacted and otherwise approves the victims.
Yes, Judge, I do see that note from Mr. Rosinko.
Were there multiple victims?
Yes.
All right. So am I ordering on multiple people and reserving?
Yes.
Okay.
I was also told there was no early termination on probation.
Correct.
Okay.
All right. What else?
Okay. And then for 20 MM 1658,
Do we,
adjudication of costs on the trespass and the petty theft. And I believe he wanted to just go ahead and order restitution for Circle K. For the,
hold on. On the DUI, wouldn't there be additional terms for the probation? Or did we cover that already?
We covered that, Sheriff.
Okay. Sorry.
He told me $5.77 to Circle K.
Right.
He told me that was for count 2. And count 1, he held the no trespassing order at the Circle K.
correct, yeah. And adjudication of costs on that.
All right. You got everything? Okay. No problem. All right. While we're finishing this up, Mr. Brennan, did you hear everything that your attorney said with regards to the plea agreement?
I did, sir.
All right. And is it your intention to accept that plea deal today?
Yes, sir.
All right. Would you please raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down, please. Mr. Stewart, as soon as Lisa's ready, I'll wait for her to give me the nod, but no, take your time, make sure it's right.
Okay, the DUI is done. You could do that one.
All right, can we go ahead and do a call clean while you're working a second to distract you?
No.
Okay. All right, Mr. Stewart, go ahead.
Okay, sir, please state your name and your date of birth.
Timothy M. Brennan, 5/2/1965.
You're entering a plea today to 1 count of driving under the influence, 3rd offense with property damage, which is punishable by up to a year in the county jail. 1 count of driving while license suspended or revoked, which is punishable by up to 60 days in the county jail. 1 count of trespass in a structure or conveyance, which is punishable by up to 60 days in the county jail. And 1 count of theft, petty theft, 2nd or more, which is punishable by up to a year in the county jail. Do you understand the terms of the plea agreement that your attorney put on the record?
Yes, sir.
And knowing that, how do you wish to plead to those 4 counts? Guilty, not guilty, or no contest?
No contest.
Your attorney's advising you to plead no contest, sir.
No contest.
All right.
Have you read and signed a waiver of rights plea form?
I have.
And do you understand all the rights on that form you're waiving when you enter your pleas in these cases?
Sorry.
I did.
And do you understand you're giving up, as a part of this plea, your right to have a jury trial in these cases?
I did.
You also are giving up your right to have your attorney file any motions on your behalf or to argue any defenses on your behalf at trial. Do you understand that?
I understand.
You understand DUI, theft, and driving while with a suspended license are all enhanceable offenses, meaning if you commit them again in the future, you could be charged with more serious crimes, including felonies.
I understand.
You understand a consequence of this plea is that potential consequence of this plea is that the DHSMV may impose additional sanctions against your driver's license and your driving privilege beyond what the court is doing here today. Do you understand that?
I understand.
Do you suffer from any mental illnesses?
And Your Honor, he is diagnosed with mental illnesses. He's being treated for that by the psychiatrist in the jail. So,
Okay.
but I don't believe he's impaired by any means.
Okay. Sir, are you taking any medication right now?
I am.
And that's medication that's prescribed by a doctor?
It's psychiatrist prescribed by my psychiatrist, yes, sir.
Okay. Are those medications in any way affecting your ability to understand what you're doing here today?
No, sir, I'm listening.
Okay. Are you currently under the influence of any other drugs or alcohol, anything you're not prescribed?
No, sir.
Do you understand if you're not a citizen of the United States, these pleas could be used against you in a deportation proceeding?
Understand.
Are you satisfied with the advice and representation of your attorney?
Very much, thank you.
And do you have any more questions for her or for the court before you go ahead and enter your pleas here today?
No, sir, I understand, thank you.
Okay, the state will tend to the pleas.
I reviewed the probable cause affidavit in 21 CT 622. I've also reviewed the notice to appear in 20 MM 1658. Having reviewed both, I do find there is a sufficient factual basis and venue. I've considered the colloquy and find the plea to be freely, knowingly, and voluntarily entered. Therefore, I will accept the plea and impose sentence as follows. Starting with, can you scroll just a little bit for me, please? Scroll up, please. Thank you. For 21 CT 622, for the charge count 1, DUI, third offense outside of 10 years with damage to person or property. Adjudication of guilt, $388 in court costs, $2,000 fine, $50 cost of prosecution. 1 year ignition interlock. License suspension?
1 year.
1 year. 1 year license suspension, please. 12 months of probation. Special conditions of probation are as follows. 84 days in the Colorado County Jail with credit for all time served. 84 days are also to be credited towards the total term of probation. There you go. That's in there. Additional special conditions are as follows. You must undergo a substance abuse evaluation and follow any recommended treatment. You may not possess or consume any alcoholic beverages, nor entering bars, taverns, saloons, pubs, lounges, or package stores, or any other establishment whose primary purpose is to sell alcohol. No alcoholic beverages in your residence. You must attend and successfully complete the victim impact panel and DUI school appropriate phase. 10-day vehicle mobilization. You must perform 50 hours of community service. You're subject to random breathalyzer and urinalysis at your own expense. There's going to be an order of restitution payable to who?
Judge, I don't know if we want to put all the victims' names on there or just say generally to anyone, to any victims in this case.
I'll go looking for restitution court reserved to all victims.
That's fine.
That's fine with me.
All right, all victims. Court reserves jurisdiction to award. Court reserves jurisdiction to award restitution to any victims named in the information, regardless of whether or not the charge itself was no process. This is by agreement of the parties. Correct?
That'll work.
Correct. Yes.
And the court reserves jurisdiction to determine amount.
You done with one?
Defendant shall report to probation within 24 hours of release. And the parties are agreeing as a condition of the plea that there'll be no early termination of probation. Now we're done with count 1. State announces a no pros on counts 2 through 5. Is that right?
Yes, Judge.
All right, and then count 6 for the charge driving with license suspended, adjudication of guilt, time served, composite costs. So now moving on to 20 MM 1658. starting with count 1 for the charge of trespass, adjudication of guilt, $220 in court costs, $50 cost of prosecution, time served, may not return to the Circle K at 1998 Santa Barbara Boulevard, Naples, Florida. Count 2 for the charge of petty theft, second or subsequent offense, adjudication of guilt, time served, $5.77 payable to Circle K in restitution, composite costs, 90 days to pay all financials. And I believe that's everything. Did I get everything right?
I think so.
All right. Mr. Brennan, good luck to you. Mr. Brian, it's good to see you.
Nice to see you, both of you, again.
Mr. Stewart,
Good to see you too.
are you super busy this afternoon? Would you have a minute to come over and chat with me about something?
Sure.
All right, let's see you in a bit.